my name is Vincent Power, and I'm honoured to be the current chairman of the European Maritime Law Organisation. And on behalf of everybody involved in EMLO around the world, you're very welcome to EMLO's first ever webinar. EMLO is the European Maritime Law Organisation, and it's the world's leading organisation dedicated to European maritime law. And I know that some of you have been new to EMLO, so you're very welcome, and we hope that you'll stay and join us. To join the EMLO family is very straightforward, it's very easy. You just go on www.emlo.org and you can join. As I say, joining is easy. Missing out on the knowledge and the shared experience and the companionship could be devastating, so do join. And to turn to this particular webinar, it's sad that we've had to gather together in a webinar format because of the entire pandemic which the world is facing. And we're very conscious of that backdrop, and we hope that you and yours have been safe and spared the terrible tragedy. But we also think of seafarers and do spare a thought before the day is out about seafarers who are either alone or suffering either from the illness or from the tragic consequences of being alone and being marooned and isolated. And as we know, there are thousands of seafarers across the world who have to be repatriated still and are uncertain about their future. So against that human backdrop, we've gathered together experts from across the world, from Asia through Europe to America, to actually discuss the legal aspects of COVID-19. So while we're looking at it in a very sort of scientific, legal way, we're very conscious of that human backdrop. And before introducing the speakers that you'll see in this webinar, we just want to say thank you to everybody in EMLO who has been involved in organising this, Sarah and Tess, but also to Goris and Fiederspiel, who've done a fantastic job at making the technology work and gathering this together in this format. So thank you to everybody. And if you join, you'll get the benefit of this even more, because not all these webinars will be free and open to everybody. That's the value of membership. So let me introduce to you the speakers that we've gathered together. They really are the creme de la creme of experts in this area. We've got Kirsty Nicholson, who's the Competition Counsel and BHB Bulletin in Singapore. We'll talk about the Asian and the ASEAN approach and bring out some really startling statistics, like the number of Indian seafarers, over 40,000 who are suffering because of this. And then we'll turn to Professor Francesco Minari of his law firm in Genoa, who will talk about the Italian dimension, bringing out the enormous economic, but also the legal and operational challenges, talking as well about the particular sectors which have been affected. Then we go north to Martin Andrea Dittmer, who's the managing partner of Goris and Fiederspiel, who not only deal with some of the Scandinavian aspects, but also deal with some of the European Union aspects as well. Then we stay within Europe, if not the European Union, and we go to London to Rob Murray, who's a partner in Michigan de Ray, who, while Martin is the Secretary General, Rob is the Treasurer of EMLO. So he's wearing two hats in today's event, and he's going to talk about essentially the Brexit and some of the other European Union aspects of COVID-19. And then to bring matters to a close, we go to Washington and the hugely experienced Jeffrey Lawrenson, who is chair of the Transportation and Trade Practice and co-chair of the International Practice of Cousin O'Connor in Washington, D.C. And to those of you of a certain generation, he's like our Alistair Cook, who's bringing the letter from America. And he's able to bring not only his experience and expertise, but also a very coherent and very lucid description of the US arrangements and practices in this area. So we hope you enjoy this particular webinar. We hope you participate in EMLO events going forward. And we'll just start now with Kirsty, who's joining us from Singapore on the Asian perspective.
And many thanks to EMLO for inviting me to speak at this groundbreaking event in the form of a webinar. Can you hear me okay?
Yep, perfect.
So I'm based in Singapore, and within Asia, we've been dealing with the COVID-19 and its impacts for a number of months, having been the first region to be affected by the pandemic. I think for the most part, the countries in Asia are considered to have managed the situation well, and they've taken swift action, including nationwide lockdowns and enhanced community quarantining measures in order to contain the virus and its impacts on both human life and supply chains. Now, for the most part, these measures have been implemented at the national level. However, we have seen some increasing policy convergence on certain aspects also at the regional level. An example of this is within the ASEAN bloc of Southeast Asian countries. ASEAN, like other countries in Asia, had learned lessons from the SARS outbreak in 2003 and had already taken some steps to prepare itself for another pandemic type incident. In ASEAN, notably, ministers met very early on and agreed that ASEAN will remain open and continue to support international trade, and it will not hinder the flow of food and essential goods, and especially medical products, and that it would seek to minimise disruption to the supply chains in the region. Indeed, ASEAN has made a number of statements at the regional level in relation to the pandemic. The most recent of these was on the 9th of June, when the ASEAN experts group issued the impact on the economy and a commitment to work together. Like,
c'est très chiant aussi. Hein.
I think some people need to mute. We've got some background noise.
It's
so
Bianchino, if you could mute.
And apologies, the Singapore Air Force is flying over my flat right now, so there may be some background noise from me. Thank you.
Perfect.
So I was just going back to the ASEAN Experts Group on Competition. Like regulators in other parts of the world, they also confirmed that despite the challenges of the pandemic, competition laws continue to apply and will be enforced during this time. They confirmed that further, as individual national regulators, they would be strengthening their cooperation and their exchange of information and best practices to address any anti-competitive activity amidst the pandemic. Now, whilst this statement was released in the context of COVID-19, I think we can expect to see this increased cooperation continuing into the future, and perhaps also amongst other regulators in the region. Staying on the subject of competition law regulation for a little bit longer, I think we've also seen competition regulators across Asia taking a similar approach to regulators abroad, where in other parts of the world, where they're taking a more flexible approach to collaborations between competitors that are aimed at mitigating some of the impacts of the collaboration of the pandemic. This flexibility has shown itself in terms of the speed at which they review requests for their blessing on collaborations, but also the types of collaboration that they are willing to bless. If we extend Asia a little bit geographically to include the wider APAC, so Australia, the Australian Competition and Consumer Commission in particular has been very active in providing speedy interim authorizations to a number of collaborations. These can be authorized within a matter of hours, 24 hours, less than 48 hours, rather than the weeks it would normally take. However, it's clear that any collaboration must be related to the pandemic and to address its impacts, and also the duration of the collaboration must be the duration necessary in order to address those impacts. And we've seen already that some of those interim authorizations coming out of the ACCC have fallen away. In fact, as circumstances change and as the collaboration has proved unnecessary. So that's been a very positive development. I think it shows that regulators can respond quickly to different situations when they do. Turning to the maritime industry more specifically, briefly, of course, the industry is fundamental to ensuring international trade continues to flow. And whilst ASEAN has made this regional statement about staying open, it is an intergovernmental organisation and not a supranational institution, which means that it's the implementation and regulation is at the national level. So we have seen some differences in the approaches taken amongst individual jurisdictions within both the wider Asia and ASEAN as well. Two main impacts for the maritime industry that we have seen, and these are the same globally, are first the increased port congestion as retailers and manufacturers are unable to pick up their cargoes in containers. This is exacerbated by reduced workforces at some ports. India, for example, has reportedly asked its ports to waive some of the demurrage and other charges for delays in arrivals and berthings in order to address some of these issues. Ports such as Singapore have had a lesser impact as they focus more on containerization, they have more automation, and so there's more limited person-to-person contact. Malaysia, pretty early on, they had adopted a limited exception to their measures to control the pandemic that specifically permitted freight and logistics companies to collect cargo to ease congestion at certain ports that were nearing 100% of their storage capacity. So we have seen these discrete measures to address some of these impacts. Of course, as Vincent mentioned, by far the biggest impact has been on crews who've been subject to lockdown measures. This has had a huge impact in Asia in particular, where we have countries such as Philippines, China, India, and Indonesia, who are amongst the biggest suppliers of crew members globally. In early April, the India Times reported that around an estimated 40,000 crew and seafarers were stranded on all types of vessels, waiting to return to India alone. So, you know, these are large numbers we're talking about. There are a number of impacts which Vincent has touched on. I can see that I'm running out of time, so I won't repeat those. But I think, you know, what is clear is that the impact for crews is a global issue, not a national issue. And in this respect, the pandemic has highlighted a significant gap in the international framework for supporting crews and managing the situation in a sustainable way. So there seems to be an opportunity there for some global standards in order to deal with the measures for the disease prevention in relation to ship-to-shore interaction going forward.
Brilliant, Kirsty. It had the model of clarity and lucidity and timeliness, which is the only thing that we can ask. So you have set the marker now for everybody else to follow. And in case anybody thinks there isn't a bell, let a warning go out to the other speakers now. So there is a bell, and if everybody was able just to unmute, it would be fantastic. It just will eliminate the background noise. So from Kirsty's very lucid and clear, as I say, and timely presentation, we move across to Italy, to Francesco Minari, who I believe was advising the Pope this morning on issues and is now able to join us, which is wonderful. Francesco.
Thank you, Vincent. Thank you, everybody. So I'll talk about the Italian situation with some flash on the Mediterranean. Of course, I think, as everybody knows, the transportation and maritime industry in particular have been dramatically hit by the COVID-19. Even though the supply of essential goods and medical equipment have been always assured. This said, there has been a big crisis, not only in the supply, but especially in the demand of goods due to the lockdown situation. Italy reckons a loss of GDP, which will be higher than 9% this year, And the volumes, since Italy is a very keen in exports and import of goods, especially in the export side, we think that about 70% of the transportation volumes will be kept this year. So we reckon with a loss of more than 30%. Now we are out of the so-called best or worst situation, the lockdown, in which we have experienced some new events as far as transportation industry is concerned, compared, for instance, to the 2008 crisis, because in those years, the freight rates actually dropped enormously, while this time what the carriers did was just to start the so-called blank sailings, which means that very many voyages have been cancelled. There have been port congestion, but this has allowed the level of freight rates to remain more or less decent, so to say. This said, again, the harbor traffic has been lost by 20 to 25%, and we again think that by the end of the year, these figures will not change very much. This phenomenon is also due to the fact that many carriers have decided not to cross the Suez Canal any longer. So the Mediterranean has been skipped, especially from the Far East trades, which prefer to circumnavigate Africa. And due to not a hasty demand for goods and the low prices of oil or bunkers, it makes these routes now more profitable. This means that the whole Mediterranean ports will probably suffer also from this side. And that's as far as liner container shipping is concerned. Of course, you all know that there have been other sectors of shipping that have been even more dramatically hit. Ro-ro traffic have been experiencing a sort of lockdown, especially as far as cabotage is concerned, and short shipping as well. And not to talk about car carriers, because the automotive industry has been virtually paralyzed, so we don't have any vessels moving. And cruises is one big problem that will endure. I don't have time to devote to this issue, but I'm studying carefully the cruise sector, because it will not probably overcome the crisis in a short term. It will be probably a shift in the demand of this touristic activity, which will affect substantially Italy and the Mediterranean as one of the major, let's say, the goals and destination for cruise passengers. Then a sort of, let's say, slowdown in the activity has been also due to increase of control and in ports, both for goods and for passengers, for those remaining passengers, which has also determined an increase of activity in terms of checks and controls, and therefore less efficiency in ports. What has the legislature done so far in this sector? There have been plenty of law which has been enacted, some of them in line with some EU relaxation decisions, which will be, I think, addressed by speakers following my speech. And we had, in general, I don't have time to go into the details, we had in general a sort of tax holiday, at least for a while, for port duties. This is also in line with amendments that have been done in the Regulation 352 of 2017. So withholding taxes, social security contributions, and compulsory insurance premiums have been also, let's say, suspended. A decrease of taxation and concession fees has been also decided, as well as a renewal, an automatic renewal, and this could be more problematic from the EU law viewpoint, of any authorization and concessions. We know that this has been done in the airline industry and with the Regulation 969, but this has not been done for ports. I don't know whether it will be scrutinized by the Commission as something which is against the freedom to provide services or state aids, whatever. There have been a substantial, let's say, public expenditure to sustain transportation, especially maritime transportation. Short sea shipping in Italy availed itself of bonuses in order to increase the modal shift from road to the sea. And this we call mare bonus, or sea bonus, has been increased and in order to keep lines working. I don't have many minutes left. I want just to point out something on which I wrote about the airline industry. The impression that we have is that this virus has probably put some criticism on the existence of markets that had inherent failures in them. So in the airline industry, this is very clear, but also as far as ferries are concerned, we thought we had a free market offering adequate supply for movement and for connection of people, which all of a sudden disappeared. I do not know whether this will imply some further thoughts on having a so-called public service obligation as far as connections, short sea shipping are concerned. This is something on which I think legal scholars and policymakers should also take some notes. Now, Christy has already talked about seafarers. I want just to add on top of that that the situation of seafarers has been also very bad, especially as far as cruise passengers, but especially cruise employees that are not seafarers that have been blocked on board of vessels. Many of those vessels have been kept also out of our ports. Now, a few days ago, the law has changed. All these vessels are allowed to touch Italian ports without operations. I know I have been talking with the Coast Guard, the head office yesterday morning. Protocols are now being prepared consistently with the IMO guidelines in order to allow a sort of restart of this activity. And I hope that in the next days the whole situation will turn to be better. So I think I have exhausted my time, and I'm clearly available for any further question. And I thank everybody for listening to me. Thank you.
Francesco, you may have exhausted your time, but you have not exhausted our patience, our intellect, or our interest. What you've said in a very crisp, succinct way has touched so many issues, state aid in particular, and the question of PSO obligations and so on. And that's a very neat segue, actually, to go north now to Martin Underdickmer in Copenhagen. Martin.
Thank you so much. I've been asked to cover the EU dimension together with Rob, and there are many topics and little time, but I will make reference to our esteemed chairman who has written an article in the Journal of International Maritime Law, which is titled COVID-19 and European Union Shipping Law, an Interim Analysis. So if ever you have the time, then you should just dive into that, because that gives you an excellent overview. So I will be touching upon the competition law aspects of merger control and a bit about state aid, as you mentioned, as well as the COVID-19 situation in Scandinavia from a regulatory perspective. And then Rob will cover competition law aspects of agreements and the relation to the EU and Brexit. So first on merger control, on 13 March, the European Commission encouraged companies to, quote, delay merger notifications originally planned until further notice where possible, end quote. And that has now been changed to, quote, stands ready to deal with cases where firms can show very compelling reasons to proceed with a merger notification without delay, end quote. And that, of course, triggers the question, can we see any change? Well, the answer is yes. but it's probably not what you would expect. And I'll go through that one by one and then conclude. So did we see fewer notifications? No. The past week, we've had 7 merger notifications, and the same period last year, we had 3. And since 13 March, we had 78 notifications, and the same period last year, we had 77. So the numbers actually increased for the summer period and stayed the same for the entire period.
We got the picture back.
The next issue is, did we see fewer clearances? Again, no. So cases have not been standing still at the Commission so far. We've had 88 clearances compared to 87 last year. Did we see more simplified notifications? No, we didn't. Since 13 March, we've had 22 Form CO filings compared to 14 for the same period last year. I think Mr. McGordon needs to...
Sorry, Martin, I wonder if there is one person, I think, who is not on mute, 2 people who are not on mute at the moment. If they could just go on mute, it would be great. Thank you very much. Sorry, Martin. Martin, you may be on.
Yeah, now what was very interesting is, as we were bragging about before we went online, I thought I was the host, but the host just muted me actually. So, okay. Going back to, did we see more derogations from the standstill obligation? No, 0 this year actually. Did it affect the practicality of notifying? Well, not that much. I mean, the Commission has been good at establishing case teams the week following the case team allocation request. They're generally reverting with questions within 5 business days from sending drafts as they used to. And the Commission case team is still available, even working from home. And they have also relaxed the rules so you can submit electronically and must just send the original until you get before clearance, basically. Now, the Director General, Olivier Gerson, he has said that the EU has suspended deadlines in cases where the notifying parties have had trouble supplying internal documents where they were not available online. And they've stopped the clock also in situations because of parties having difficulties in answering a detailed request for information due to the lockdown conditions. And they have actually exercised these rights, if you look at it, because the past month there's been 2 deadline suspensions, and the past 6 months there's been 5 deadline suspensions. But it's a bit difficult to conclude because in the more complex cases, they stay in the system for 1 to 2 years, and data for the past 3 months does not reveal that much. Turning to substance, in terms of substance, Vestager has stated there's no need to relax the normal merger control rules. The Commission has also stated that they will not be softening its approach to failing firm defense. And such statements in a crisis have implications also for the shipping industry, because even during a crisis, the world does not stand still. So my conclusion is that COVID-19 has not really had the big impact on the figures and practicalities, at least for the simpler cases under the short form CO or the form CO. And actually on our side, we've been able to get a number of cases through, and the last one was the Danish bunker holding who acquired OCM very recently, and we got a merger clearance well before the expiry of phase 1 actually. Now we have the ongoing debate in this respect on how to structure shipping pools. Do we go for notifiable full function joint ventures or horizontal cooperation subjects? And there are pros and cons, of course, of having a notifiable full function joint venture where you get a decision from the relevant competition authority, or having a cooperative joint venture where only a self-assessment is needed. And during this period of crisis, the self-assessment route can be even more appealing. And indeed, also we have had, and I don't know whether Rob will touch upon that, but we've had the extension of the consortia block exemption during the COVID-19 crisis. So even though the European Commission is acting relatively quickly in merger cases, other competition authorities, they may not be doing the same, which again speaks in favor of self-assessments. Take South Africa, they are immediately seeking for an extension of the deadlines upon notification. Ethiopia is not accepting any filings. Ecuador has stopped the clock unless it has sufficient information, and Argentina has suspended all review until 28 June, just to give a few examples. Now, second, turning to state aid. As we all know, state aid plays an important role in parts of the European shipping industry. And on 8 March 2020, the Commission published a working document which was entitled Overview of the State Aid Rules and Public Service Rules applicable to the maritime sector during the COVID-19 pandemic. And even though it's not legally binding, it is worth a read, and it gives guidance to the Commission's approach. The aim is to safeguard and restore the connectivity underpinning the free movement of persons and goods, while keeping in mind that a competitive internal market is the best way to bounce back strongly afterwards. That is what they state. And they recognize that support to shipping company as well as port operators might be needed, and it can take many forms: grants, loans, public guarantees, tax rebates, referrals, and also that member states may require, as Vincent pointed out, to impose public service obligations on operators to replace or support commercial offers that become unavailable during this crisis. And I think that the document is very helpful in providing some guidance on how to navigate these difficult waters during the pandemic. And several member states have already implemented measures to support the shipping industry, but there are also concerns, serious concerns about state aid issues, because can you disguise state aid through the different packages that you make available to the industry? And that is certainly something we need to be aware of on behalf of our clients. Which leads me to the third and final point, the COVID-19 situation in Scandinavia, being difficult to define in itself. I will include Denmark, Finland, Norway, and Sweden, and not Iceland. I hope nobody objects. And within the maritime industry, all 4 countries have made it possible to extend seafarers' certificates, which is very positive. However, we've seen that the COVID-19 has had a severe impact on crew changes. In many instances, this has not been possible. And now Sweden, for instance, they've relaxed the rules on safe manning in circumstances of exceptional urgency, as I've stated. And the master of the vessel has authority to decide that the ship shall undertake a voyage even if the crew does not comply with the normal requirements. Finland, they have offered financial support to 5 passenger car ferries operating under the Finnish flag, 1 operating under the Swedish flag, and 1 under the Estonian flag. And these are ferries operating the Helsinki, Tallinn, Turku, Stockholm, and Vaasa-Umeå routes. And in Denmark, there have been a political agreement to dedicate 60 million euro to boost export, which is primarily aimed at the maritime industry. And in the newspapers today, we could read that the newest attempt would be that you can take ferry crossings without your car for free within Denmark. Now, ending with merger control, deadlines are suspended in Denmark. Finland is planning to extend the scope of phase 2 proceedings, and Norway, they've added an extra 15 working days to their deadlines. Sweden, as the only Scandinavian country, and in line with what we see as a very unique approach to the whole COVID-19 situation, they are continuing business as usual. That was it for my part. Vincent, over to you.
As they say in the Eurovision, thank you, Copenhagen. That was absolutely wonderful. When you think about the breadth of what Martin has covered, and to do so at such great depth, it is extraordinary. So thank you very much indeed, Martin. We'll come back to some questions later, no doubt. So if we can turn to that part of Europe that we call London, or indeed Southampton maybe perhaps, because the great advantage of this webinar is that we're all being invited into each other's homes. So if I may call upon Rob.
Thanks very much, Vincent. So I'm going to try and talk a bit about the combination of COVID-19 and Brexit, because we in the UK are gluttons for crises, and we're going to have two instead of one. I'll also talk a bit about some competition law issues that are coming up, and I'll try not to repeat the excellent comments that have already been made. So the British experience of COVID-19 is not being fantastic in terms of the number of deaths and the handling of the crisis. But what we have seen is that we have at least managed, largely because we have a number of very large supermarket chains, we've managed to feed ourselves. For some reason, the panic buying focused on toilet rolls rather than things you can actually eat. So I'm not quite sure why that was, but we didn't run out of them. So not after a few days. What we've seen is a doubling of online grocery buying. It's now about 17% of the market, but most of that has been fulfilled through effectively manual solutions rather than technology. So we've had a lot more people employed because most of the infrastructure you just can't make quick enough. One of the problems that we have, a grocery company called Ocado, they have a very digital automated model, and they have been stuck with that capacity constraint. So we've managed to feed ourselves. The lights have kept on. We have thrown a lot of money at certain problems, but interestingly, we haven't thrown money at the airlines. There's a judicial review about the quarantine measures that are going to kill the airline industry. And there is an issue, I think, about, and then probably in other countries as well, which is, well, if you want a competitive market, then it's not competition just within a single mode. So some of the routes that are most international for the UK, for example, crossing the channel, you've got several modes of transport. You've got ferries, you've got trains, you've got planes. And so there's an asymmetry between the treatment of those modes. So we've now effectively got a nationalised transport, rail transport. We've got some aid given to the ferries. We've got no real specific aid given to road, although road is actually probably the most important, and no aid to airlines. So I think that's an issue on state aid, which I'm not supposed to be talking about, but the idea of symmetry of aid between markets and between sectors and countries, I think, is going to be a big one. A segue into a comment, which is, it is amusing that having told Germany for decades that they should spend more money, they're now being criticised because they're spending more money. They're spending half of the total state aid that's being spent in Europe. There will be long-term consequences for that, I'm sure. Now, we also have Brexit to cope with. I've been quite close to that issue. My money is on a no-deal Brexit or a tiny deal Brexit. Our government has said that on no account will they have a transition, which is, given that virtually everybody is telling them that we won't be ready and it's a really high-risk strategy, is about as irrational as you can get, but there you go. We've also told the world that as from the 1st of January until July next year, we're not really going to have border controls for imports into the UK. That's because we haven't got our act together on border control. That is an invitation for all the fraudsters out there to flood our market with all sorts of wonderful goods. And obviously our European neighbours are not going to be very impressed and will be exercising, quite rightly, strict controls at the border. So we'll have lots of rubbish coming in and we won't be able to fob it off onto Europe. So that'll be interesting. And we'll complicate the matter by probably doing some mad trade deal with the Americans, whereby we add various low welfare foodstuffs into our market, which will also encourage everybody else to put controls in on re-export. The bigger point, I think, is, well, what has the pandemic really shown us? And I think at the top level, it is, well, it's shown us that supply chains as they exist are not fit for purpose. And it doesn't matter whether they're regional, national, or global. We have become very, very complacent about relying on single sourcing. You know, the UK, we have no ability to do our own testing, make our own vaccines, etc. That will change, and with it will the supply chain. So the buzzword is sustainability, which is code for let's have more than one source of supply. You know, in the distant years when I used to do commercial work many years ago, and it was not quite as it is now, it was common to be doing, you know, the second or the primary supply contract for a particular client. Very uncommon for the client to effectively only have a sole source of supply, because they recognize that had inherent risks. So that's one thing. And the other thing is that, certainly from a UK perspective, I think we need to see the world in terms of, can we feed ourselves and all the other stuff? So it's, can we feed ourselves and keep the lights on and all the other stuff? Well, in the pandemic, we've been able to feed ourselves, but we haven't done Brexit yet. So there's a question mark about, well, will we be able to do the same thing after Brexit? And then keeping the lights on, well, we do rely on interconnectors and all sorts of other things, which I strongly feel may be problematic. So that's an interesting one. And then the other stuff, well, most of it comes from the Far East. Is that really such a great idea? Coupled with that, I think, is you are seeing increased protectionism. As we were preparing for the seminar, I saw an RSS feed saying that the EU has published its paper on proposals for mechanisms to deal with subsidized companies operating in Europe. For subsidized companies, insert China and possibly Hyundai in shipbuilding, but it is a real concern that we don't really have effective measures. We don't have effective measures in liner shipping, etc. We have no measures anywhere else. So that's another thing to watch. And as ever, I think what people have shown us is that the maritime sector in many ways is reactive to what other people have to do. So that the supply chains are not really often created by shipping companies saying, you know what, let's run a line from here to here and see whether anyone will put some stuff on our ships. And the other interesting thing about it is that it relies on two types of assets: the ships, which are inherently mobile, and the ports, which aren't. So you have different effects. The ships can be moved around the world. There are lots of tankers full of LNG. I think LNG prices are now negative because they're paying people to take LNG to try and store it somewhere. And on the other end of the spectrum, you've got car carriers with nothing to do and everything in between. So in terms of competition issues, and I don't know how many minutes I've got left, but logistics, we've seen relaxation of the rules, cooperation between supermarkets.
Just one.
1 minute. Cooperation between pharma companies. The genie's out of the bottle. Will the new buzzword be cooperation rather than competition? I think there are certain countries and certain ministers who would love that idea, and I don't think the genie will go back in the bottle very easily, despite measures limited in time. The thing I haven't seen is the use of competition law to get out of agreements. I've seen lots of articles about force majeure. There are lots of agreements which, if the parties decided to review their self-assessment, they might persuade themselves might not be as pro-competitive as they once were, and competition law might be a viable way of a viable alternative to force majeure, particularly if combined with an arbitration clause that you can do it all behind closed doors. And I'll stop at that point.
Again, another tour de force. Fantastic, Rob. In fact, there's a question about the issue of frustration or hardship or even force majeure in the context of charter parties has popped up. So maybe when we're finished from Jeff's presentation, we might be able to deal with that, and volunteers such as Francesco and Rob and Jeff and others who feel they want to deal with that would be superb. So last but not least, let's go to Jeff in Washington, D.C. I must say Washington, D.C. has changed a lot since I was last there, judging by the background. But Jeff, you must be not just a great lawyer, you're also a great photographer. Wonderful shot behind you. So Jeff.
I'm appearing virtually with a virtual background, and I can tell you it looks a lot better than my exercise bike. Just to see if the real background was there. Good evening, everybody. Good afternoon. I thought that previous presentations did a great job giving a view of a lot of different implications of the COVID virus, and touched on issues that I think are very germane to what I'll try to address in the 7.5 minutes I now have left. For most of us in the U.S., I think there was a great deal of surprise when COVID arrived at the apparent lack of a well-coordinated legal and administrative process in place nationally to cope with the epidemic. We all just assumed here that the CDC, our Center for Disease Control, which is part of our Health and Human Services Department in the executive branch, would take care of things, as has occurred in the past with less intrusive epidemics. In fact, the process is well defined. If you look at the regulations, and it has quite extensive powers to establish, the CDC does to establish and enforce quarantine and other public health requirements in epidemic situations, including those relating to navigation specifically. There are regulations and provisions dealing with that. And if you go to the CDC website, you can see the program that it has laid out for the cruise and the what they call, I believe, non-passenger sectors, which would comprehend cargo, offshore, etc. However, in the larger U.S. economy, for both political and institutional reasons, the role of the federal government as the national organizer, facilitator, director is not asserted, or at least not clearly asserted in the eyes of many. And I'm not making that as a political comment, but just a factual one in terms of how it was perceived. Certainly at our ports and borders, as it relates to maritime, traditional roles were asserted. The CDC oversaw public health and quarantine measures, such as the no sail order, which is still in place and will be for at least another month. Cruise vessels. The Coast Guard oversaw vessel entry, crew requirements and transfers, and navigational safety. Customs and Border Patrol, CBP, oversaw immigration requirements, again, including having a piece of that crew transfer issue. However, maritime these days doesn't end at the ports, and once one went inland, it was largely left to state and local officials to establish requirements and provide necessary resources, including PPE and rules for the transport of goods, albeit with some general guidance from CDC and some help from HHS. And to a large extent, that's where marine cargoes must move inland, both consumer and industrial goods, but to a great extent, those officials weren't prepared for this. And this provides some background, I think, for my specific comments today, because I thought it would be interesting as lawyers to look at a situation that has developed here that's occurring in the US, because we have an interesting contrast between two regulatory approaches. These are subjects that will focus particularly on the competition and maritime regulation areas that have been in EMLO's traditional wheelhouse, if you will. As some of you may know, the US Department of Justice, along with the Federal Trade Commission, issued a joint statement in March in which they said they would expedite processing of certain business review letters to 7 days, which is a rocket speed level compared to traditional processing of business review letters. BRLs, as they're known, are statements by the DOJ Antitrust Division of its intent not to challenge a proposed joint venture or other cooperation amongst competitors, typically competitors. These letters take quite a bit of time to get, a lot of effort. They're infrequently issued. And the two agencies said that they would expedite the process essentially for cooperations intended to respond to COVID problems or to assist the government in doing so. And they have, in fact, in the last few months approved 3 such proposals, all relating to PPE and to medical remedies. And this, I believe, is a commendable response of a regulator, albeit one not likely to be helpful to the maritime sector, to be frank, and a rather conventional response, but similar to what regulators are doing elsewhere, some flexibility. But along with Martin's comment, I would say that the DOJ statement came with a reminder that they would prosecute any companies seeking to use the crisis to engage in anti-competitive activity. So a little flexibility, but more of a concern that some people might try to game the system. Now, down the street from the DOJ, so to speak, is a little-known federal agency that some of you have heard of, the Federal Maritime Commission. It's been around for 100 years, and it has some extraordinary authority in the maritime sphere. Basically, the FMC regulates liner shipping, cargo, and passenger, something not often recognized, which today is basically the container business for cargo and the cruise business for passengers. The organic statute of the agency, the Shipping Act of 1984, has the FMC regulating cooperations amongst ocean carriers and amongst marine terminal operators, and it confers antitrust immunity to the Department of Justice's great dismay at times on agreements. And one of the Act's purposes is to regulate, to, quote, promote efficient and economic practices in transport. So the FMC, by the way, also oversees cruise line bonding requirements, which covers refunds. In a sense, a kind of analog to what our DOT does in the aviation area, in terms of ensuring that passengers have some consumer protection relating to that, as well as that there is a bond for passenger injury and death claims. It would not be surprising, certainly to all of us, if carriers, cargo or passenger, came to the FMC seeking antitrust immunity for cooperations relating to combined operations of assets. But in fact, that really has not occurred to any great degree. Something else quite interesting has happened. The FMC has embarked on 2 efforts to, in my view, explore the boundaries of what a regulatory agency can do in a situation where there appears to be a lack of government focus in the executive branch. It turns out that nobody is really paying attention, close attention at least, to how the marine cargo intermodal system works as it relates to that inland area that I mentioned earlier. And this is in one of the largest economic markets in the world. And that's probably not a good thing if you think about it, with COVID disrupting trade patterns, because in recent years we have seen supply chain disruptions of great significance throughout the United States relating to rail, ocean, and motor carrier intermodal terminals arising out of trade volatility, labor disputes, hurricanes, trade embargoes, tariff impositions, to name just a few in the last 7 or 8 years. It became clear that for international cargoes moving by ship via port to or from the US, we had a vulnerability. And then, of course, COVID came along. So the FMC has issued 2 fact findings, one in the passenger area, one in the cargo area, in which they're doing something quite unique. They're not only seeking to find facts, as a regulator might traditionally do, but they have authorized the fact-finding officers, which are 2 commissioners, Commissioner Rebecca Dye, who oversees the cargo side of this, and Commissioner Solo on the passenger side, to convene key stakeholders, including stakeholders that are not technically regulated by the Federal Maritime Commission, to sit and talk with each other. And we know in the transportation area, it often is a zero-sum game, where you have many actors acting logically in their own economic interests, which yields an incredibly illogical result for society and for the transport system and supply chain in general. Those efforts have begun. There is no time frame on them. but they are both going on. Much of the discussion is behind closed doors. There are periodic issuances, which you can see on the FMC's website. So I'll close by just saying that in contrast to what has seemed in some areas to be a somewhat reluctant federal response that has been conventional, in this little agency, we have an unusual effort to try to foster forces, certainly an unusual role for a regulatory agency. And I would suggest that since Commissioner Dye has appeared previously at EMLO events, stay tuned for a future EMLO seminar for the results of all. Thank you.
Fantastic. Fantastic, Jeff. And I really do hope clients were watching this event, because it's a wonderful demonstration of how you can get expert lawyers to download so much information so succinctly in a wonderful period of time and be ahead of schedule. This is absolutely amazing. What we're probably going to do, Martin has reminded me that we're all going to turn into pumpkins like Cinderella at the top of the hour. So we have to end before 1500 hours Copenhagen time, 1400 hours London time. Is that right, Martin? We have to finish. Okay, so therefore. So what we might do is, I saw your very good question about frustration. I might share that with some of the speakers, and then we'll try and get back to you directly on that. But also, I've seen some other questions pop up as well, some really interesting questions, and we might share those for another seminar or webinar. I think this has been so successful. Let's try and do another one very, very shortly. And we might even get Philippe Rutley, who I see there on screen looking like he's in his surgeon's scrubs. Maybe he's offering to speak, but others will speak as well. And I would encourage you to join EMLO, to become part of it. What you've seen today, as you look across the arc around the world, you saw Kirsty described so brilliantly the speed at which regulators have responded, the collaboration, new permissions, but you also talked about the human dimension, the 40,000 seafarers from India alone on those cruise vessels. You heard from Francesco, who described so graphically all the implications for Italian GDP, but the practices, how the ro-ro sector, short sea shipping, car carriers, and so on. You have to think perhaps that this is also going to be, in years to come, that moment where, a bit like the airline sector post 9/11, certain anti-competitive practices started. And you saw from Martin, who gave his tour de force covering 3 areas, so magisterially about the merger control regulation, gave us hope for our business plans that there's still work out there, also talked about the fading firm defence, self-assessment and so on, and also talked about seafarers and how those rules had to be liberated to allow elongation and prolongation of certificates and tickets for seafarers. Rob, fresh from his success before the Supreme Court, yet another one. Does that man ever lose in the Supreme Court? Whether it's no, he says not. That could be misleading advertising, Rob. But he's clearly successful after the Gina Miller case, the Gina Miller 2 case, and now Sainsbury's. But about feeding ourselves and how all of this has been important, and the role of shipping in the supply chain, and also Brexit. The fact that there was going to be a possible no-deal Brexit meant so much was stockpiled. That actually saved some of the issues in COVID-19. And then Jeff, who, as I said, COVID came as a great surprise, but showed how the agencies are responding and how interesting the FMC and Commissioner Dye and also our friend Rick Krasinski, who, you know, that whole dimension is really important. What you described there, Jeff, is really, really incisive, because as you say, it's one a huge market. Also, we would see it as a free enterprise market, and as yet you described some interesting restrictions and all of that. So as we're drawing it to a close in terms of the crisis, I think it'll be interesting to see that the collaboration that is there between operators, which has been permitted, that's going to be difficult to end, and we might slip ourselves into anti-competitive arrangements unknowingly. State aid, as the chief economist of the OECD said yesterday, there will be huge distortive effects and competitiveness across Europe, but I dare say across the world, because as Rob was saying, and Martin was saying about the level of state aid in Germany in particular, that's going to be important. Those who had spent more, and there's going to be a distortive effect there. the PSO and ferries, that's going to be interesting. The lockdown was easy. It's the crank up that's going to be more difficult. What you had, ladies and gentlemen, is a fantastic tour de force by experts, as I say, from Asia through Europe, through to the Americas. I hope you join with me in giving whatever way we do this now on Zoom a tremendous round of applause to the presenters who have done so well. So the best thing you can do now is support them in their efforts to spread the news. Join EMLO on www.emlo.org, and we hope to see you at the next webinar, but more particularly, we hope to see you in person at one of the events very soon. So sign off, be safe, be well. Take care.